From Arizona cowgirl to Supreme Court justice, we are taking a look back at the life and legacy of Sandra Day O'Connor, the first woman ever named to the United States highest court, who died at the age of 93. She was appointed by President Ronald Reagan back in 1981 after a career of firsts in Arizona politics. And while O'Connor was considered a conservative pick, she became known as almost liberal when the Supreme Court shifted to the right, often becoming the swing vote. Now, that gave her considerable influence over major decisions, and her 24-year tenure was often referred to as the O'Connor Court. I'm joined now by Bhamati Viswanathan, faculty fellow with the New England School of Law, and Martha Davis, distinguished professor of law at Northeastern University, where she teaches constitutional law, U.S. human rights advocacy, and professional responsibility. Thank you both for being with me. So I'm going to start with you first, Bhamati. You know, when you heard this news about Sandra Day O'Connor reflecting on her life and legacy, you know, we were talking a little bit about teaching and things like that. What came to mind for you?
Of course, I think every woman thinks, what a trailblazer. I loved her. I respected her. At times, I feared some of her opinions because she didn't always line up with me. Yeah. But I always respected her so much as a person and as a jurist. She's a role model. And when you're starting out in the legal profession and you look at other women who have really trailblazed for you, it's with this huge burden of gratitude, but also just so much admiration. No matter what, she was so thoughtful, so kind, compassionate to everyone she talked to. And yes, her opinions were fabulous and she was brilliant, but she was also someone who thought about the impact that she would have on people's everyday lives. And I appreciate and think about that every day.
Martha, you know, she presided over some landmark cases that are still being used, cited, quoted on today.
Still being used, sometimes being questioned by the current court.
Right.
I mean, I think the thing that came to mind for me was just a recognition of how far the court has shifted to the right since she was on the court. And you know, I agree with all the things that we just heard about her trailblazing, you know, sort of role. But by the same token, she really kept the court in the middle, and it really has drifted so far to the right since then. So, for example, one of the very important cases that she authored was the affirmative action case, Gritter versus Bollinger. And, you know, the court has now departed from that precedent very recently now. So that was a case that where, in her court, in her opinion, she upheld affirmative action by the University of Michigan Law School. And now we know it's been struck down or you know, disallowed at Harvard in the most recent term.
It's such an interesting case when you're talking about her appointment. She was considered the conservative pick, but then ended up, as you mentioned, being the one that kept the court in balance. And now we see a very different Supreme Court and what that landscape looks like.
That's right. I mean, when she retired, one of the things that I really noted, I was in practice at the time, was the way in which the court moved to the right. Kennedy, who had been kind of pulled over to the middle by her, you know, forming a kind of a group with Souter at some points, you know, no longer had those allies in the middle, and he definitely drifted far to the right along with the rest, and brought the rest of the court along with him.
Yeah, do you see this as an interesting, like the landscape of the court or the nature of the court now versus the court that Sandra Day O'Connor sat on? It seems to be so different, even though she was considered a conservative.
The court, the Times,
yeah,
right? The
yeah.
Times, people today. But I want to go back to what Martha said for a second about that. So the University of Michigan Law School decision came out literally a year after I graduated law school, and Dean Bollinger, Lee, wherever you are, I still admire you enormously, was the dean at the time. And I noticed with those decisions, because there were really two decisions. There was a decision at the law school level and a decision at the undergrad level. And at the law school level, she said, yes, this can be an important factor. At the undergraduate level, she said, you can't give 20 points to each student and just treat it like a quota, and that was struck down. And you notice her sort of taking a very careful centrist path and thinking what's happening in these specific circumstances. That kind of scrupulousness, that kind of care, and sort of splitting, the Solomonic splitting of the baby was something that the court, I think, actively engaged in and wanted to do in order to create coalitions. That's really not what we see happening now. We just kind of see the court sometimes going, you know, oh, precedent, whatever. And it's a very different kind of decision making. It's a different direction, and it is more partisan, I think. And it's troubling because it sort of reflects what's happening in some ways in the country as well. And I think it must have been hard for O'Connor to see her legacy of just scrupulous jurisprudence being taken in a completely different direction, as Martha says.
Especially when we're hearing politicians, you know, say that we're moving in a way that seems unconstitutional in the courts. And I was also thoughtful in researching for this interview that she walked into a court where the house or the building itself didn't even have a woman's room.
Right. Yeah. And I mean, she was a very strong person, for sure, you know, to deal with that kind of thing. And while I'm not sure she thought of herself as a feminist, she definitely, because of the places that she found herself in, was, championing women's rights frequently. During the time she was on the court, part of the time I was practicing in a women's rights organization, and we couldn't count on her vote, but we knew that she was supportive of a lot of the things that we did, and especially when it involved something involving stereotypes of women or areas where there were explicit discrimination against women. She was definitely very sympathetic and empathetic, about that. So. The case for which she's maybe most often cited is, speaking of precedent, is the decision in Planned Parenthood versus Casey, where she and Justice Kennedy and Justice Souter came together in this three-justice opinion that upheld key components of the right to abortion. And in particular, the one part that they of the Pennsylvania law that they struck down was the provision that mandated that a woman go get her husband's permission in order to get the abortion. And she really understood that the kind of exposure that might give women to abuse, to violence against women. Yeah. She herself had been active in the Junior League in Arizona when they had taken up violence against women as a particular campaign issue for them. And so this was something she understood as a woman, and she, that showed up in her opinions, even though she was conservative on federalism, she was conservative on many other issues. But on the women's rights side, often she really understood what the issues were and was, siding with Justice Ginsburg, of course, but siding also bringing Kennedy, bringing Souter, along. So it was a very important voice that she had on the court, especially at the time when she was the only woman.
Yeah, I mean, when you look back on her nearly 25 years on the court, abortion, affirmative action, voting rights, religious liberty, gay equality, free speech, all before retiring in 2006. It's incredible.
It's incredible. Campaign finance. There's other things you haven't even mentioned. And I'm just going to jump on my hobby horse, which is I do intellectual property law, copyrights and trademarks. Nobody wants us to go down the road of talking about all those cases. But what she really did in those cases was she tried to balance free competition, which she really believed in, right, as the engine of free expression. Copyright is what she called it, right? And on the other side, the rights of individuals in their works, in their creative works. And that's something I care deeply about. I write and talk about it all the time, particularly with respect to women and minorities. BIPOC rights are really an important thing to me personally. But she saw that from the start, that by upholding people's rights in their property, in their work, this is something that will actually benefit all of us, right? And that will reward people for what they do. Now, some people think, well, her emphasis on personal property and private property went too far. That depends on where you fall on the spectrum. But you could see, even in her cases, she would reason it out. She would think about, again, how it landed on people, how it affected people. And I got to agree with you so much, Martha, on Casey, when she talks about spousal consent, why that might be so burdensome for a woman to have to ask her husband, her husband, right? We think of that as outrageous these days, but then it wasn't considered so outrageous. She thinks about how it lands. She didn't quite think as much about how it might land on poor women to have a waiting period or to have to go back for their termination, right? Yeah. And I think that it was easier for her sometimes to see certain sides than other sides, but none of us have perfect vision on these things.
Right.
And she did her best, and she cared deeply about how will this play out. And she was also somewhat, I think she was humble and said, listen, we need to be very careful about how the scope of our opinions, because you can't tell what's going to happen in the future. She literally said, you don't want to have regrets down the line, and you don't know how things are going to turn out. And I think that's admirable, actually. She was a very careful jurist.
Absolutely.
Yeah, I think that's right. I mean, thinking about the spousal consent piece, one aspect of that case is that it came up through the Pennsylvania federal court system, and Justice Alito, who was on the court then, the lower court, before he ascended to the Supreme Court, upheld the spousal consent provision. And so that gives you a sense of how the court has changed. That the person who would have upheld that is now writing the Dobbs case.
Right. Same thing in the campaign finance reform case. Am I forgetting the name? What's McCain-Feingold, right? Campaign story, right? She just said, look, there's the potential for corruption here with these gigantic campaign finance donations, contributions. And the person who said, no, that's really not a problem. I don't see that problem, Kennedy, who she had to persuade on that opinion, several years later overruled it and said there's no potential for corruption here. So you can see, even in her lifetime, but certainly after her lifetime on the court, I mean, this rowing back, this completely, fairly systematically dismantling her legacy on the court and many of the things that she held most dear. And someone asked her, how do you feel about this? And she was awesome. She said, how would you feel?
Yeah.
Right? And, she said, of course I'm disappointed.
Yeah.
Right? But, you move on. And she was very much a pragmatist. Right. And she knew that, things change. And we still, as law professors, I think, hope and believe that things will change as well. Law is not static. We were just talking about this, right, Martha?
Right. Yeah. I mean, it's about, for us, anyway, teaching law students about argument. It's about learning how to present the issues in ways that might illuminate them anew, and so I guess that's the posture that we're in now with a lot of these issues.
Right, and you yourself led the fight at Now Legal Defense Fund, and it's true. Martha Davis here is one of the leaders for women's rights in the world, and you know what it's like right now, sort of looking at what we're facing, but you don't put down your sword. You just say, listen, students, sometimes I say to them, like, I'm tired, you take up the sword now. It's your turn, yes. Young people, go for it, right? But that is why, precisely why I'm teaching you, because you are going to lead the way. Things are not static in the law.
Yeah, certainly an extraordinary legacy. Bhamati Viswanathan, thank you so much for being with us, and Martha Davis as well. Thank you so much.
Thank you.